As we predicted he would do, Donald Trump has just filed a motion in the Manhattan District Attorney criminal case where he was convicted on 34 separate felony counts. His motion is to dismiss the indictment and vacate the jury's verdict, finding him guilty on 34 separate felony counts based on the United States Supreme Court's decision regarding absolute presidential immunity. You'll recall the United States Supreme Court said three things in its ruling. First, that Donald Trump would be entitled to absolute immunity for core constitutional functions. Second, Donald Trump would get absolute immunity for official acts, and there should be a broad presumption that anything he or any president does in office constitutes an official act. And third, the admissibility of evidence is an issue as well, and any evidence of official acts that a president engages in while in office must be deemed inadmissible and cannot be presented to a jury, cannot be presented to a court, cannot be presented at the time of trial. And so here in the Manhattan District Attorney criminal case, there was testimony from the time Donald Trump was in office, testimony from Hope Hicks about Donald Trump's state of mind while he was in office. There was testimony from Donald Trump's personal assistant in the White House about Donald Trump receiving mail. There was testimony about when Donald Trump was in office where he invited David Pecker to show up at the White House. There was testimony where Donald Trump invited Michael Cohen to the White House. There was testimony how Donald Trump received checks at the White House. And so what Donald Trump is arguing is because that evidence was deemed admissible and was shown to the grand jury and then provided to the jury at the time of trial under the Supreme Court's ruling, that evidence was inadmissible and it therefore tainted the entire proceedings such that the indictment should now be dismissed based on the Supreme Court's ruling. So to be clear, Trump is not arguing that the falsification of business records itself constituted official conduct. The argument here is an evidentiary one, that the proceedings provided evidence to a grand jury and ultimately to the jury that they should not have received about things when Trump was in office, and that the Supreme Court's guidance is basically that none of that none of that should have been admissible to begin with. Let's just take a look at what Donald Trump's motion is so you can understand it. We'll break it down a little more. It says that Trump submits this motion to dismiss the indictment and vacate the jury's verdict based on presidential immunity, as articulated last week in the Supreme Court's decision and based on the Supremacy Clause. It goes on to say how, Your Honor, Justice Merchan now has the authority to address this, and the court is duty-bound to do this in light of this Supreme Court decision. Under the Trump Supreme Court decision, the district attorney violated the presidential immunity doctrine and supremacy clause by relying on evidence relating to Trump's official acts in 2017 and 2018 to unfairly prejudice Trump in this unprecedented prosecution relating to purported business records. And then it goes on to say much of the unconstitutional official acts evidence concerned actions taken pursuant to core executive powers for which there's absolute immunity. Overall, the impermissible official acts evidence included Trump's private conversations with the White House communications director, observations by the director of Oval Office operations regarding Trump's preferences and practices in the Oval Office, and with respect to national security matters, such as use of Air Force One and Marine One, as well as secure calls in the White House Situation Room, allegations of conversations regarding the pardon power, and official communications by Trump using a Twitter account that has been recognized as a formal channel of White House communication in the Trump administration. And then it says, because of the implications for the institution as ruled by the Supreme Court, this case now needs to be dismissed. When I read the Supreme Court's ruling, the first place my mind went to, and you can go back and look at the hot take that I recorded right after the Supreme Court's absolute immunity ruling, was I said they were also giving him a roadmap to dismiss the Manhattan District Attorney criminal case. Because again, even though the criminal conduct at issue in the Manhattan District Attorney case predates Donald Trump's time in office, the Manhattan District Attorney's office, the court, and Trump were talking about evidence of the time and nature when Donald Trump was in office. They were talking about communications while Trump was in the White House. They were talking about those things. So the question ultimately that's going to be before Justice Merchan is, was the admissibility of that reversible error? Or is it basically just, non-significant in nature, such that even if that evidence was permitted, the verdict should still stand as is? Or did the admissibility of that taint the full process? Donald Trump then goes on in this motion to talk about the types of evidence that he believes should have been inadmissible. Let's just take a look at it so you understand, if you're still confused, like, what are we talking about here? The crimes took place before. Yes, the crimes took place before, but one of the things that Trump's arguing here is, look, testimony of Hope Hicks, White House Communications Director. The district attorney used its subpoena power to require Hope Hicks to testify about her interactions with Trump during his first term in office. At the start of Trump's term, Hicks joined the administration as Trump's Director of Strategic Communications. In that role, her responsibilities included working to showcase Trump's accomplishments and the agenda of the administration. In August 2017, Hicks became the White House Communications Director. Between January 2017 and March 2018, Hicks worked in close proximity to the Oval Office. It goes on to describe what her responsibilities were. And then it says Hicks testified in the trial about her official capacity communications with Trump and the press concerning the January 12, 2018 Wall Street Journal article that was admitted at trial as Government Exhibit 181. Hicks explained that the Wall Street Journal contacted either herself or another press communication team member prior to publishing the story. The article included 2 comments from an unidentified White House official. The district attorney elicited the identity of the White House official and asked Hicks the following: "And as the communications director at the time, did you discuss this statement with Trump before it was issued?" Answer: yes. Hicks testified that after the article was published, she spoke to Trump about how to respond to the story, how he would like the team to respond to the story. In January 2018, an organization known as Common Cause made a complaint relating to Trump and Cohen to the FEC. In approximately February 2018, Hicks spoke to Trump about a New York Times article that included a statement from Cohen saying that he had in fact made this payment without Trump's knowledge. And then it goes on to Hicks' testimony. You remember that very devastating testimony where Hicks broke down and cried and said that, she believed that Donald Trump was aware of what Cohen was doing because Cohen wouldn't have went rogue. He would have been following Donald Trump's instructions at all time. That took place, though, in the White House when Donald Trump was in office. So Trump's arguing under the evidentiary part of the Supreme Court's absolute immunity, that evidence should not have been admitted because it took place while Trump was in office. Testimony regarding, then it goes on to testimony regarding the special counsel's office and congressional investigation and the pardon power, testimony regarding Trump's response to the FEC, testimony of Madeleine Westerhout, the special assistant to Donald Trump. Then it goes on to say subpoenas were used to have Westerhout testified about how Trump likes speaking with people in person or on the phone, how Trump took calls each day, the process that Donald Trump did when getting mail, how the phone calls went down, why certain checks were received, why certain checks weren't received. Trump used an organization system and brought papers with him on Air Force One, how Trump would mark things up with a Sharpie. And so Trump saying official acts, Supreme Court, that evidence should not have been allowed to go before the jury in the first place. And then what Trump uses over here is says, look, in the district attorney's own closing argument, they said that this was some of the most devastating evidence against Donald Trump to prove Donald Trump's mens rea or mental state. During the district attorney's summation, the prosecutor repeatedly emphasized inadmissible official acts testimony. Trump writes, he cited Hicks and Westerhout as example of witnesses that the district attorney believed provided damaging, utterly devastating testimony, which were critical pieces of the puzzle because they have no motive to fabricate it. Steinglass later described Hicks and Trump's own employees as Trump's own tweets as the corroborating testimony that tends to connect Donald Trump to this crime. So that's how they use it there. And then one of the things that they cite as well in this brief is that when some of the arguments were being made to Justice Merchan, Justice Merchan said, look, there's no such thing at that time as any immunity regarding the evidentiary value of things, so I'm going to allow it in. And Trump saying, well, the Supreme Court just said you should have allowed that in now. So that's what Trump's arguing, that the evidence shouldn't have come in. As a result, dismiss it. We'll wait for the district attorney's brief and to see what they have to say in response. And I think they'll say, look, to the extent there was, any error, it should not be reversible error. It's harmless error. And there was a ton of other corroborating evidence other than this. That's what I expect the district attorney's office to argue. But the moment I read that Supreme Court decision, you'll remember I said they were giving him a roadmap right there to the district attorney's case to say certain evidence was allowed in, it shouldn't have been allowed in, and that case should get dismissed, even though that wasn't even what was before the Supreme Court. It was obvious that's what they were doing. We'll see what Justice Merchan rules, but I just want to lay out the facts for you, what this is, what's at stake, and how horrific that Supreme Court absolute immunity ruling is and how broad it is. So tell me what you think. Hit subscribe. Let's get to 3 million subscribers. Together, we'll keep you posted with more updates.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.